May I be permitted to mention, my lord, on the original side, my lord? Yesterday I mentioned that matter, it was not taken up. Learned Advocate General's matter was taken up at 2 p.m., my lord. The matter is not in the list. Lordship had extended the interim order for 1 week of 18th of March. Kindly extend the interim order, my lord.
1 week is 25th.
25th, my lord.
Tomorrow, don't worry.
Kindly, my lord.
Who's the
Well,
deputy?
again, my lord.
No, nothing.
Well-
It will come. Yes,
Lord, may I be
Well,
permitted?
Then let the matter appear tomorrow, my lord.
it will come tomorrow.
Lord, may I be permitted to mention a matter? Yesterday, I was trying to impress your lordship to get the matter be heard unlisted, but now I have filed it. And
Sleep.
Permitted to mention on group 7 appeal along with the applications.
Well, may I permitted to mention one assigned matter, my
What is I?
my lord? It is a one criminal division application, my lord.
Criminal
case-
revision.
My lord, it's a special bench matter, my lord, assigned to your lordship, my lord.
Us, both of us.
No, my lord, that matter has been heard by your lordship on lastly on 31st March 2023, my lord.
Assignment is to which bench?
My lordship,
Bench presided over by me or bench with somebody?
that don't know, my
That
lord.
I don't know. A fighter देखो तो और करो.
Subject to leave of my Lord Justice Prashad Malas. May I have your lordship's kind leave to mention, Malas? Malas, there is a review petition number 14 of 2024, Malas, which was listed before a lordship on 8th of February, Malas. Lordship was pleased to direct the registry to release the matter on first week of February, Malas. First week of March.
Sitting with whom?
Sitting with Justice Prashanjit Vishwas, Malas. Malas, he was in circuit bench.
Talk to him and one day we'll sit. Don't worry.
Malas, if it is possible, Malas 27 or 28, Malas, I am coming for some particular
Subject to the availability of my brother, Justice
Malas. Lordship can, being the presiding judge, Lordship can take the
No,
initiative.
I can't impose anything on anybody.
I'm not saying Malas imposing or Lordship. If Lordship can accommodate me on Malas, review petition number 41 of 2004, Lordship can have a look at it, Malas. It was listed on 8th of February 2012.
If we can.
If Lordship can remember this matter, Malas, Lordship can have a look at it, Malas, and please give some dates in this matter.
Yes.
I'm grateful to Lordship, Malas. I'm grateful.
Number 11, your lordship, of your lordship's today's list. I filed a cross objection, your lordship, that was the objection is not appearing. Let
It
your
will,
lordship
give the number, it will be brought.
Ever lordship kindly mention a matter, my lord. First appeal, my lord, of 2020. This is ready matter, my lord.
Wait for some time. There are many appeals which are appearing 10 years, 20 years old. Let us dispose of some of them. We'll definitely take care. It will appear tomorrow. Why? It will appear tomorrow. Tomorrow it will appear, your application.
To mention on item number 367.
Yesterday you mentioned. Yes, it will be taken up. Don't worry.
1 minute. For only direction for service.
I know that you said. Both of us has a good memory, excellent memories.
No, today if not.
We don't forget.
Today if not, when they come at 2 p.m.
Let us see. It can reach.
If not.
If yes.
My lord, I am for the appellant and the matter has been settled between the parties.
Can 5 has been filed, a joint compromise petition. But two duties I have to discharge as husband. One I am discharging today, my lord. So Lordship kindly takes up page 5. My lord, 40 lakhs I have to pay. I am paying it, my lord. If Lordship kindly record by demand draft, I have already given him the copy. Page 5. My lord, page 4 it starts the terms of settlement. Page 5.
No, this one has been given to us. Can 5. Page 5, I do not find any reflection of 40 lakhs.
My lord,
Page 6, my.
page 6. My lord, it starts from page 5. Page 6, clause 4.
Yes.
Clause 3, my lord, I have taken 1 month time to
Yes.
execute it. Clause 4, my lord, I am complying here and now. These are the two stipulations, my lord. 3 and 4.
She want to withdraw. The decree for divorce has already been granted.
The divorce decree granted by the London
Now,
Grand
now
Court.
you do not want to proceed with the
In view of this compromise.
Is this?
Lord, the petitioner, Lord, your lordship, sir, please
Oh.
to, Lord, appoint Mr. Vaidya as special officer to deliver possession.
My lord, I am.
Taken?
Yes, my lord, I have taken the possession and my lord, I have sealed all the rooms available there. I think all I have. And my lord, this is my report, my lord.
Acquisition of the said property from the respondent.
बोले तो बंजे इससे हमरा तो कैसे बोल बन जाता है नहीं
Revert back.
So that we are
put a copy given to
and then let the suit be proceeded. Follow. How many appellants are there? Only one?
no three appellants three respondent one.
All three have to take possession.
Lord, your lordship directed him to put a padlock on the door, and if your lordship directs to hand over the lease,
He will not be able to identify. So we are directing the keys to be handed over to you.
Yes.
And then you take the responsibility because you are representing all the appellants.
all the appellants.
ठीक है 5 Whose articles are there?
Well, nobody, before I appeared there, everybody removed their article.
Oh,
Only two rooms, they had padlocks, they removed. I requested them, they peacefully removed, my lord.
and that is all empty.
Yes, my lord, every room was empty, almost empty. There is a picture also showing the respondent opening the padlock upon my request.
Yes, that one lady,
Yes,
it
yes.
appears
She is,
to
my
me.
lord, Pratima Nashri.
It's a residential accommodation.
But what
And
I,
some sub-rooms are also there.
what I found, my lord, this is not a gated property, my lord. In front there is,
The structure shows that it can't be a gated property.
yes, ma'am.
Yes. Come. Pursuant to the order dated 15/3/2024, the special officer appointed by this court submits the report in a sealed cover, in a sealed envelope. We directed the ACO to open the seal. Stop. Upon perusal of the report, the report which on perusal of the report, we find that the special officer has taken possession of the suit premises and have also put a padlock thereat. The keys of those padlocks are lying with the special officer.
No, my lord, I have annexed in the report as well. Report. Controlling.
Why you will annex it? You are not supposed to.
I tender my apology.
The keys of the padlock are also annexed to the report in a separate envelope. The possession of the decretal property was obtained on the basis of an ex parte decree for eviction, which was subsequently set aside by the competent court. Despite the decree having set aside, The position was not handed over to the judgment debtor appellant, which constrained him to take out an application under section 144 of the Code of Civil Procedure. By the order dated 15/3/2024, we set aside the order of the trial court, by which such application under section 144 was dismissed. 144 of the CPC was dismissed. Since the position was obtained on the strength of a decree, ex parte decree, which was later on set aside, we do not find any justification in the stand of the decree holder to retain the position. But they should restitute the position in favor of the judgment debtor. We therefore direct the special officer, we therefore direct the ACO to hand over the sealed envelope containing the keys of the padlock put by the special officer to the advocate on record of your advocate on record?
Yes, Mr. He's here.
No, tell him to come.
Yes.
You should not appear, Mr. Ghosh.
Not here.
This is not expected.
Lord, yes. Lord, he is taking. He's coming.
To the advocate on record of the appellant, who in turn will hand over the same to his clients upon a proper receipt. Since the position has already been given to the appellants, nothing left in the instant appeal to be decided further. Accordingly, the matter shall be shown to have been disposed of. In terms of the order dated 15/3/2024.
Before disposing of my two submission, must go on record, Milord.
Hey, এটা না রিপোর্টটা রেখে দিও, শুধু
Milord, my two submissions may be taken on record, Milord. Milord, the suit property was a bare land, 3 katas, 21 shotoks out of 3 katas. Now, Milord, without any boundary wall. Padlock has been put on 6 rooms, which is not part of the suit property, not. What my client told me, he was present. Milord, they asked the special officer to identify the property. It was also not done. It is a bare land, not Milord rooms. It was never. One. Number 2, this application has been filed by the constituted power of attorney, who has been sold subsequently by the defendants. Now, Milord, the defendant, my specific submission is either she has expired or dead. Therefore, Milord, this constituted power of attorney has lapsed as of today.
My lord,
These two submissions
with expression, my lord, the respondent has not, my lord, complied with my lord's order. They have not paid the remuneration, my lord.
These two submissions may go on record.
paid first.
Definitely.
Paid.
Now, Milord, I did not have, Milord, they did not say it.
Sorry. Why it will not?
They are not in a position, Milord.
Sorry, can't.
Well, let the, Milord,
That the attitude of the decree holder is well known to us. Every attempt was made to thwart the decree.
Milord, it is a settled, Milord, it is there on record, even it has.
Sorry, we can't.
It is a vacant land.
Sorry, then what position you took? What was a vacant land? Then why these shop rooms were there? Why you have taken a decree?
No, we did not.
Did not take a decree.
Vacant land. It's a vacant land. But possession has been taken over stockroom, which is not even my client ask the special officer to identify which is the suit property. That
is definitely a good advice from the legal brain came. That is what is the trouble we noticed on the 15th of March. That is what we noticed. Where is the bailiff report? Mr. Ghosh, do you have a bailiff report? Give it to us.
That is not correct.
Give it to us.
So I have opened.
Oh, I can't read. Can you read?
Yes.
Tell us.
So kindly see what they have.
I am not on that. Let them give the bailiff.
মালিপুকুরিয়া গ্রামে রায়ত দখলটি সত্য বিশিষ্ট সত্ত্বে এক জমার 21 শতক জমির তার বার্ষিক 1.125 জমার মধ্যে বিকৃত 3 কাঠা জমি আকাশ পুরোপুরি পায় না 25 পয়সা শতাংশ জমির মধ্যে 3 কাঠা জমি 9 ইঞ্চের দেয়াল বিশিষ্ট অ্যাসবেস্টসের ছাউনি যুক্ত কামরা ঘর
6 rooms.
Which is all the boundary, the wall with the over it.
You can
This is there with a shed over it.
well, kindly see what they have purchased. Kindly see.
We do not want, sir. You got possession from them on the strength of a decree. Decree was set aside. It is your duty to return back the possession. You can't stand and say that no identification. If the bailiff has said that what he has taken, that's enough. Pay the remuneration.
I'll ensure that.
Pay.
Ensure that.
Yes. Call the next one.
Well, I am for the appellant, my lord.
Sister, catch up with to see.
Well, this is for a direction for preparation of paper book, my lord.
Take out an application, put in the requisites. Madam, you filed the appeal in 2022, and it is really an unfortunate that more than 1.5 years elapsed. You could not put in the deficit court fee of 20.
Yes, my lord, I have.
1.5 year.
6th January 2000.
I have seen that. And when the appeal is of 2022.
September 22.
How, why you will take so much of time, madam? 20 rupees and 3 pages. And 3 pages of the order sheet was wasted only for recording that you have not put in the deficit court fee of 20 rupees.
I am sorry, my lord. It came to my knowledge later, and my lord.
Came to my knowledge, when you file it, is it not a duty of the advocate and record to see that there is any defect?
I'm sorry.
Then what for the advocate and records are there?
1.5 year, not 1.5 year, my lord. 21st September, the matter was filed. And my lord, 6th January 23, the
How many? October, November, December, and then you come in a January near now I amend near more than 3.5 months.
yes, my lord.
Can you
Yes.
not? Is it expected? Limitation has intervened in the meantime. And unless the court extends the time, you can't put in.
I'm sorry.
Then we are dismissing it because without leave of the court or extension, you have put in after the limitation.
My
We are
lordship,
dismissing them. Appeal
lordship,
on that.
lordship may kindly condemn that, my lord. It's my fault. I admit, my lord, this is my fault.
There is no noting. There is nothing. You have not put in the requisites. Those are required to be put in along with the memorandum. And you are coming without an application that we should pass an order for direction for paper book.
In my lord, I shall file an application.
Dr. Kureda, go out of this just.
Lordship, I appear for the appellant.
Should pass an order to dismissal of.
Lord, I appeared for the appellant. But this was an appeal from an order of refusal to pass the ad interim order in a suit. Your Lordship was pleased to pass an interim order. And this is that matter where your Lordship directed the learned government pleader to ensure that it is served on the defendant respondent. That was served on that point of time. But now, once again, when we have sought to serve the order, it has once again come back.
With what remark?
Insufficient address. But the same address the police had found on the last occasion. And the report is in my lord's records.
Who appeared for them?
Nobody appears. Despite service, nobody appeared. So, my lord, what I was humbly beseeching is subject to what falls from your lordship. But if your lordships kindly take a look at the 19th January order of your lordships. By an order dated 22nd November 2023, we directed the appellant to serve copy of the application upon the respondents, as well as the learned advocate representing them in the trial court, which in fact had been done. Even on the last occasion, we directed the officer in charge, inspector in charge of the concerned police station to effect the service of the said application, and we are informed by the learned government pleader that the service has been effected. Let this report submitted by the learned government pleader with regard to the effectuation of the service in terms of the aforesaid order be kept with the record. So the service was effected, and thereafter your lordship was pleased to pass this order. And if my lords kindly turn over to page 2, your lordships were pleased to pass the interim order for a period of 8 weeks from the date of the order. Kindly sees the last paragraph.
The construction is going on or not going on?
At present, it's not going on. After the order, they have stopped. But I do not know, my lord, whether they're watching it and they're not appearing, and I do not know. But despite service, they're not appearing. So, my lord, what I was humbly beseeching, subject to, of course, what falls from your lordship.
We are extending the interim order because the appeal is not listed.
Yes.
That is the whole problem.
I
The
understand.
notice of appeal and
I
all
understand.
everything,
I
they may
understand.
come and take a plea of this.
Absolutely.
So we can't, we wanted to dispose of in their presence,
Yes.
but
if they are not appearing, if I may humbly submit one thing.
let the construction be stopped for the time being. Where is the difficulty? You are happy with that?
Yes, I am happy with that. My lord, what I was humbly beseeching, if this
the interim order granted earlier is extended for a further period of 6 months from date or until further order, whichever is earlier. the appellant is directed to put in requisites for effecting the service of notice of appeal upon the respondents within a week, by the end of March 2024.
But could it be first week of April? Next week?
Sorry, Nick, that's why by the end of March we said.
Very well, we shall try. 2 days. He's not there, but he will ensure.
27,
But
28.
He will ensure. He is not there, but he'll ensure.
Sorry, do it.
I understand. We shall. So.
On filing of the requisites, the office shall ensure that the service is immediately effected upon the respondents, and shall submit and shall put a note on the file in this regard. List the matter in the 3rd week of April 2020.
My lord, and the affidavit of service has been filed.
Let the affidavit service filed today we kept on record.
I'm grateful.
Item number 5, 6, 7, and 8, Lord.
There has been a development. The development is the learned advocates who are appearing for the state are no longer in the panel, so they have given up the brief. I requested Mr. Roy. Mr. Roy said I have not been able to get the brief, so I have to allot it to somebody else. All of them, 3 of them.
How can they give up? Because I believe that they were appearing in terms of the direction of this court. They were engaged in terms of the direction of this court.
No, my lord, by the PP for the matter when it was assigned to your lordship. That's the issue because the new panel has come out. My lord, they are not there. So I asked Mr. Sudip Basu. He said I've already handed over the brief to this. So I talked to Mr. Roy.
Lordship, that's why I came before your Lordship to inform that we are not in the panel now. So, Lordship, there is a reshuffle in the panel, and we are not
no longer there.
No longer.
Have you returned all the briefs?
Lordship. Lordship, we have returned all the briefs.
Next week it can't be heard. 2 days, my lord. No, provided, my lord, they engage a lawyer because he has to start de novo.
Only keeping it not this week, what can be done? And
no, not next. I won't be.
No, only thing is let them.
No, I'll talk to Mr. Roy. I've already talked to Mr. Roy because I am in custody for 13 years.
Because he said that he returned the brief.
Yes, I've told Mr. Roy just now.
And Mr. Roy said he had not received the brief. I am really surprised.
Well, maybe the department, the office has it. He has not called me. I've questioned Mr. Roy just now.
Do not have a control over your staff. Then what type of office it is?
Sorry, man. Your lordship is right. But I'll get it done. Personally, because I'm in custody for 5 years and 13 years. So it's my. But can it be on 4th of April?
Not this week. We will not hear unless they come.
Achha, okay.
I'm good.
Great.
Yes.
I have for the respondent.
Where is the?
My lord, I am for the appellate.
Ground the accommodation was sought.
No, well,
Yesterday.
yesterday, my lord, due to my illness, my lord, I was not able to come, my lord.
And he
And my lord,
put an aspersion that since last 4 occasions, adjournment is sought on.
no, my lord, on the last occasion, my lord, matter was heard, my lord, and my lord, Lordship was pleased to condone the delay, my lord, Lordship kindly see, just 4 or 5 days before.
What is this application?
My lord, application, my lord, challenging the, my lord, order of probate, my lord. Granting of probate, my lord. My lord, appellant is the brother of the contestant, my lord, who contested the probate application. Now, my lord, there was a direction, my lord, for exchanging of affidavits of stay application. My lord, I am filing my affidavit in reply, my lord.
I am taking the point of maintainability of the appeal because firstly, there is no application for leave to appeal. He was not a party.
That is what I was just ascertaining, whether he was a party, was he an objector?
His sister was an objector who died during pendency of the probate proceeding.
Thereafter,
Sister means
own blood sister, my lord. Own blood, my lord.
Sister was the daughter-in-law of the testatrix.
Sister was the
daughter-in-law of the
testatrix.
Yes, my lord.
Who is the father-in-law?
Yes, my lord.
Mother-in-law.
Now,
mother-in-law.
Now, how you can acquire a right?
My lord, if there,
Wait, how you can acquire a right?
My lord, if there is no will, my lord, suppose my lord,
will not.
No, my lord, for the
Then also you will not.
No, my lord, my lord, if there is no will, my lord, daughter-in-law is entitled to get 1/4 share.
No.
Even
daughter-in-law, my lord, daughter-in-law.
Your husband is alive.
My lord, dead. Yes, my lord.
Suppose if, then how you will get a right?
Yes,
Tell me.
That's the coming, my lord, because my lord, during her lifetime, my lord, the contestant opposite party, she also made a will.
Yes.
My lord, bequeathed her undivided 1/4 share, my lord, by virtue of inheritance, my lord, because my lord, his husband had died, and on the death of his husband, my lord, she acquired 1/4 right. My lord, she bequeathed her 1/4 share of the property in favor of his brother appellant. And my lord, after the death of the my lord, that contestant opposite party, my lord, the appellant filed an application for probate, my lord, which is also pending in the same court, my lord. And my lord, appellant, my lord, he tried to, my lord, file an application, my lord, for my lord, so that my lord, he may be allowed to contest. But my lord, his defense was struck out, my lord. My lord, learned court held that my lord, as the main contestant opposite party died, and she has no other legal heirs, so she is not entitled. That is my question, my lord. My lord, learned court, my lord, that is my lord, has my lord apparently error in law to held that my lord, that the contestant has no legal heir or legal heir, my lord. That's kindly see, my lord.
She doesn't have a legal heir.
No.
She doesn't have a legal heir.
Now, but my lord, she made an instrument.
What instrument? That has not been probated as yet.
No, but that probate application is pending. And my lord, at the time of granting of the probate, my lord, learned judge was very much aware that this said application is pending, my lord.
Lord, under section 15, the daughter-in-law had no right.
Sir, that was in case of an intestacy. I am conscious. In case the daughter-in-law die without leaving a will, in case of an intestacy, it will revert back to her matrimonial, the in-laws' heirs. It will not go to her parental heirs. I'm conscious. That's why I was just thinking. That is only in case of an intestacy. He says that there is a testamentary.
Yes,
if he had any rights, she never acquired any right.
No,
Because
the question is not that. If the testatrix was an objector and she asserted that the will is not genuine one, then at least that cause of action that can be fought or carried on by them In the event they succeed in the appeal, and if they suppose if the appeal, in the appeal, we set aside the grant, holding that there was a suspicious circumstances, the will is ingenuine. Probability is there. Then what will happen? If the will goes, then it will revert back to the position that the testator or a testatrix in this case, that intestate.
Intestate.
Then this daughter-in-law being a class 1
No, she will not. That
is
what I'm
not.
saying. She will not. I say, I go one step back. The
whether the husband was alive or died or predeceased the testator or testatrix.
Kindly see the chart. I've given
No,
the
no,
chart.
tell me.
Yes.
The will for which the probate has been granted,
My lord.
the testator or testatrix, I do not know. Testatrix, whether her son, who is the husband, predeceased her.
Predeceased her without any issues. Now, as per section
Predeceased.
Yes, my lord.
without any issues. That is why she had no right. Because 15(1) says, my lord, firstly upon
And
the
difficult.
15 covers, my lord, no right, no caveatable interest at all. He did not have any caveatable interest. You kindly see the chart once.
No,
Yes,
my lord,
yes.
Lord, kindly take one more.
That devolved according to the set out in section 60. Preference की बात है. Firstly, upon the son the children of the son or daughter. ये है नहीं. इसमें होता है any predeceased son or daughter. To the predeceased son. Secondly, upon the heirs of the husband. Thirdly, about the mother and father. Fourthly, about the heirs of the father. Lastly, upon the heirs of the mother. Notwithstanding anything contained, any property inherited by a female from her father or mother shall devolve in absence of any son or a daughter of a deceased, including the children of a predeceased son or the daughter, not upon the other heirs referred to in subsection 1, in order specified them, but upon the heirs of the father. Any property inherited by the female from her husband or from her father shall devolve in absence of any son of a deceased or not upon the other heirs referred to in subsection 1, but upon the heirs of the husband. Husband के तरफ से ससुर की तरफ से कोई बच्चों के हिसाब से उसके ससुर की साइड में section 16.
I have given all the information in the chart, my lord. The testatrix died on 9/1/2010.
serenity also. আরেকটা আছে আরেকটা নিয়ে আসো তো আরেকটা ফাইল একটা ফাইল ওইখানে আছে নিয়ে আসো আরেকটা ফাইল যেটা আছে ওই যে
Complete such action.
দাঁড়া ব্যাপারটা Now, my lord, lordship kindly see, my lord, the my lord,
No, sir. First thing is,
examination in chief.
first thing is whether the right to sue survives is the first important. Whether you can carry it forward. The person to whom you are claiming your right, she had a caveatable interest.
Yes,
No,
my lord.
sorry, she does not have a caveatable interest. Now, if she did not have a caveatable interest, I do not know why her objection was accepted and the suit was converted into a contentious cause.
And my lord, the attesting witness also.
This is the only point which is available against him. He did not challenge that order by which the objection was accepted and the probate application was converted into a contentious cause. He did not.
At this stage, my lord, when it is carried forward to somebody who
No,
is
my
not the
lord.
original
My
person.
lord, even my lord, attesting witness, my lord, he also deposed, my lord.
You can say many things provided you have a right.
Then, my lord, no. Not my lord, admittedly, my lord, I am the my lord, legal heirs.
No, you are not a legal heir. There is a distinction between an heir. I do not know the.
No, yes, my lord, that's I follow.
I do not know the word legal heir anywhere. Heirs cannot be illegal heirs. All heirs are legal heirs.
Yes, yes.
It is the heirs or a legal representative. So you can claim as a legal representative, I can understand, but not as an heir. You do not fall within the purview of section 15. You do not fall. And if it is the predeceased son,
Yes, predeceased son. 2009, my lord.
then so far as a female Hindu is concerned, this is what I find a dichotomy. In case of a male Hindu, then the daughter-in-law is entitled as a class 1 under section 8.
Yes, my lord.
But I am surprised that in case of a female Hindu, he is not.
She is coming under 15(1)(b). Secondly.
কোনটা বলছো? Upon the years of the husband. And the house.
কিছু পাবে না সেখানে সেখানে কিছু পাবে না পাবে হচ্ছে দুই ছেলে মেয়ে শুনুন মিল না থাকে
নাতি নাতনিরা পাবে।
শুনুন মিল না থাকে
কিন্তু কিন্তু মেল হলে তো উল্টো
মেল হলো
Yes, sir.
Now, my lord, here, my lord, it said,
Difficult, sir.
my lord, sons and daughters, my lord, including the sons and daughters of predeceased sons and daughters, not wife here, not wife it is mentioned, and my lord, the husband, my lord, and the husband, my lord, and my lord, in absence of husband,
Son means a living or
Living,
surviving son
yes.
on the date of the death. The predeceased, then
1 year just.
whatever is the unfortunate situation, but he predeceased, then must be a surviving and living son. The distinction is from class 1 under
Yes.
section 8, which includes the son of the predeceased son, the daughter of the predeceased daughter, the son of a predeceased daughter, the daughter of the predeceased daughter,
And the husband.
widow of the predeceased. Husband is not, that is 15. I'm talking about male Hindu,
first schedule
class 1.
schedule 1
Had it been a testator's will,
Then, my lord,
you have a very good case. Then 15 will not apply. Because the right is vested. Once vested, cannot be divested.
yes.
He did not have the commutable interest, I do not know, but other legal heirs are given consent. The other legal heirs who are surviving, the grandson and granddaughter, they have given consent.
And my lord, within three,
We
my
can't.
lord,
According
within,
to this application, we can't grant.
my lord, within 3 months, my lord, within 3 months from the date of my lord, from the date of execution of will, my lord, testator are died, my lord. That is a suspicion. But my lord, I have no capital.
Assumption.
Yes.
That is not the sacrosanct.
Yes, yes.
That any will executed within 3 months, 4 months, or 1 year of the death will always be discarded. No.
No, that is, I'm not.
No. The
There
law
are suspicious circumstances.
presume some presumption and the strong presumption, and that they have to rebut that. And if they have proved it that she was a, who knows when the death would occur. Even a gentleman arguing before the court, and suddenly, and so vociferously argues, so nicely argues, and you don't know within 5 minutes what would happen.
No, that's.
We have seen that. We have seen His Excellency, who has passed away, delivered a lecture, in course of delivering the lecture. So who knows when the death would come?
Yes.
Can't say that it was within 3 months. So even she didn't know that she will pass away. That you can't. That is not a ground that.
But my lord, in the impugned order, my lord, just one submission, my lord, one submission. My lord, in the impugned order, my lord, learned district judge, my lord, have not taken this ground. My lord, in the impugned order, and my lord, in the whole proceedings, my lord, my lord, I am praying, my lord, this is a fit case of remand, my lord, because my lord, that question has not been arisen, my lord, in the whole proceedings, my lord, in trial court.
This is a fit case for remand, but at whose instance? At whose instance? I am giving you example. What he says is
Yes.
that suppose if there is no will,
Yes.
throw it out.
Yes.
Let us throw this will in the river Ganges. The testatrix, he died, say interstate. How her property would divorce? Okay. In case of intestacy, it must divorce.
No.
To whom it will divorce?
But when he written objection was accepted by the court.
It may devolve upon a son and a daughter.
Yes, that is the yes, my lord.
And even a predeceased son of a predeceased son
Yes.
is included, son of a daughter of a predeceased.
Yes.
But the widow of the predeceased son is not included. If she cannot inherit,
Yes.
how you will inherit from her?
Yes, but learned court, my lord, accepted the written objection of.
I do not know why.
And my lord,
under what circumstances.
and my lord,
So even if you succeed here, you are not going to get anything.
yes. And my lord, application for probate was also, my lord, application for probate was also pending, my lord. By the
probate, the court is not going to decide the title, whether
yes, that is
decide the title or
yes,
not title.
Yes.
Only the genuinity of the will.
Yes.
It will only authenticate the will, nothing more than that.
Yes.
So that is there. What is there? Who cares about it? But you will not get this property.
Yes.
Under any circumstance.
No.
Then why the right of appeal? No. Can't. You can't. You can't. What to do? Can we dispose of the appeal itself here?
Kindly do that now, because he has no right, and there is no application for leave also by him. He is a non-party. Your lordship would have allowed the leave had he not some.
My lord, my
legal
only
right to
submission is
contest.
that, my lord, this is a
He has
fit
no
case
legal
of.
right to contest, my lord,
My
because
lord, because my lord, learned court,
Not a leave.
my lord, learned court has not considered this issue.
So 146 he can come. No difficulty, sir. Claiming a title through his
My lord,
the predecessor. There is no difficulty. Not leave is not required.
predecessor didn't have the title
So
or a caveatable link.
that is not required.
my lord, I am, my lord, only praying, my lord, this issue has come, my lord, for the first time. My lord, learned court has not considered at all, my lord,
But now
these aspects.
Sir, the appellate court will shut its eyes.
Yes, my lord. That's a.
Appellate court cannot shut its eyes.
Yes,
Then
yes, my lord. But my lord,
one has to understand.
but my lord, this reason has not been assigned in the impugned order. My lord.
It's a pure question of law.
Yes, my lord.
Facts are undisputed.
Yes.
On the basis of undisputed
Yeah,
facts,
facts are
you have, then you can't. You can't continue. Doubts. Firstly, sons and daughters, and including the children of discuss. Sure.
My lord, lordship kindly see the once again the impugned order, my lord. That's before passing judgment, my lord. Ah, sorry.
Simple reason that you do not have a right to enter into a room. You are inviting. Let us see what are the articles which are lying here. First thing is establish a right to entry. Right of entry is the first.
Yes.
Then we will see what are the articles and what are the
Yes.
artifacts which are kept there of immense value. Your entry is restricted, sir. Completely closed. We are disposing of the appeal. We will not keep the
Yeah,
appeal.
as your lordships, my lord, think best, my lord.
Because no, I will be saying that he cannot get a stay. If no stay is granted in his favor, no priority case.
You know, at least me and my brother is also joining with me now. Unnecessarily, some litigation which have no merit cannot be entertained. Ultimately, we know it will be dismissed, but it will be dismissed after 10, 15 years. Then why not be dismissed here and now? Why? There must be a certainty in his mind.
On the question of law itself.
That's all. Admitted facts.
The dates given in the chart are all from the written objection by him, Milord. I have prepared the chart on the basis of the dates given in his written objection. All the date of death are his submission.
You have given a chart.
I have given a chart not giving all the dates of death. And the dates are not in the written objection, which is part of my affidavit in opposition.
Yes. Hey. Give me the judgment of Krishna Kumar Birla versus R.M. Lodha. Capitable interest in challenge করতে পারবে
Paragraphs 115, 116 possibly. 1151.
2008 for SCC.
And then 135.
2008.
Which paragraphs you say? 115, 116.
The rule of the High Court. No.
And
where is
135
relating to caveatable interest?
135 to 140.
Paragraph 135 to
That is a family interest.
That includes not this point. Family interest will include that if you have no right.
Caveatable interest, the point is there.
86 not submission was recorded. 86 submission was recorded. And 115 and 16 said it has to be decided as per High Court rules. 86, then 115, 16.
It is too thought that the submission that or is a it's too far fetched the submission. It's not ordinary. When industries, then she should have got it will be an exercise in future. You see the if there are industries who are alive, of giving the part of another form or the reverse or an act or a right that will never arise because of the first schedule or second schedule can not arise at all. Interesting.
ছোট 55 so that
Today, my draft copy of the judgment, sir.
This is also functional.
Yes, call the next.
24 malar I am for the appellant, not applicant. কোথায় শান্তিনগর এটা কোনটা there is a section 5 application and I have come here challenging the temporary injunction granted and I have served previously I have served after the order on last occasion my lord was pleased to direct me to serve again. I have served again. Before direction, my lord, I served.
How many days delay?
74 days. I filed an appeal, my lord, before the wrong forum.
10-2. 10-2 is a continuation.
Yes, my lord.
What type of section 5 it is? It has facts of the case and all, everything is narrated. Section 5. Nasruddin had a share of 17 decimal. Is it there in section 5?
Page 7 my lord, would be relevant.
There is a delay of 74 days
In from paragraph 6 onward.
in
Yes.
preparing the appeal. The application has thus been filed seeking condonation of the delay. The learned counsel, relying upon the application and the averments made therein, submits that on account of some communication gap between the counsel and the appellant, the delay has occurred which is bona fide.
As also my lord, appeal filed before the wrong forum.
Yes. And he has also submitted that some time in the interregnum was lost in pursuing the remedy before a wrong forum by filing first miscellaneous appeal. The reasons spelled out in the application we find to constitute sufficient cause for condonation of the delay. At the top, please note that affidavit of service has been filed. However, there is no representation on behalf of the respondent. If the application is allowed, delay is condoned.
Put the matter under order.
Order 41 getting us.
Order 41 it will appear.
No, no.
I 25, my lord, may I please lordship, I am for the appellant led by Mr. Murali Mohan Rai. My lord, at the outset, I submit before your lordships. This is the, yes. My lord, another copy has to be filed before your lordships because it is a reconstructed file and it's very.
Not today, filed it.
My lord, only non, my lord, I have contacted the other learned advocate appearing on behalf of the other side. she has not, I have no instruction about that. My lord, I have to serve personally to the all the private respondents. My lord, I require some more time, my lord, because this is deeply obliged, your lordship.
So I'm the applicant. So this is a affidavit we have sub the section 5 application is spent.
How many days delay?
39 days, your lords.
What are the ground?
So grounds are the 227 was filed initially. After that the lawyer advised to file the appeal. This is the preliminary degree partition suit, your lordship, and we have filed. And the lawyer was junior Mr. Tiptima Talukdar. Samom Chakraborty was COVID attack, and that's why they delay, your lordship.
Yes, there are some parties who died.
Hi, your lordship.
They were substituted. Heirs were substituted.
Years was substituted
The
and the
trial court.
trial court.
Yes.
Can 1. This is can 1. This application has been filed for condoning the delay of 50 days in preferring the appeal as per the application and submission of the learned counsel. The delay has occurred due to the fact that initially a wrong forum had been approached by the petitioner and thereafter some time taken by the learned counsels in preparation of the appeal. The reason is spelled out in the application. The reason spelled out in the application, we find to constitute sufficient cause for condonation of the delay. The application is allowed, delay is condoned. The matter it has to be rested. No. The office should formally register the service, affidavit of service.
Affidavit of service?
Yes, lords. We have mentioned and also have service affidavit.
The top affidavit of service.
Great, your lord.
Very good. Get to listen after 2 weeks. Yes, go on the next matter.
I am appealing. This is my application for maintenance, my lord. Pursuant to your lordship's direction, my lord, I have filed an affidavit stating all the
Lordship, in this matter, the counsel for the petitioner is on his legs before a different court. I am praying for an adjournment.
Which court?
Lordship, NCLT matter.
Or NCLT matter, High Court has to wait.
Lordship, kindly grants an adjournment with a short date. As per my senior's instructions.
The court has a supervisory jurisdiction or not?
Absolutely, sir.
So why the High Court will wait for?
Lordship, kindly grants an adjournment with a shorter date.
You have been told a wrong ground, at least for this bench. Is the advocate record? Shahriar Hussain.
Lordship, I am not aware of this.
Sorry, who is your senior who instructed you?
Lordship, Advocate Shayok Chakraborty. Lordship, kindly accommodate.
Tell him to appear at 12:15.
Much grateful, Your Lordship. Much grateful.
My lord, I pray for the Passover, short Passover.
Yes.
My lord, I pray for the not adjournment for today.
Yeah,
Advocate of Tandon Mukherjee,
he's appearing for whom?
appellant.
What has happened to him?
If you can- I have no brief, my lord. Actually.
What has happened to him, Mr. Tandon?
কোথায় আছে? Actually, personal difficulties that is in coming for court. Actually,
He has not come to the court.
Right now.
And if it is found that he has arrived the court, then
No, my lord.
be prepared. If anything happens, then we'll hold you responsible for that.
No, my lord. This is not come today.
Not today.
Okay. Thank you, my lord.
I'm for the applicant. This is the affidavit of service, my lord. Matter, my lord, relating to the guardianship, my lord. What happened?
Child.
Child, my lord. My lord, my wife married twice.
Yes.
My lord, item 228, my lord.
What are you doing, sir?
I sincerely
This
apologize.
is what
my
an
lord.
instruction is given to your junior.
My lord, I was held up. I did not think I'll be held up. For that long.
Why you will say that this is a ground? Is this a good ground for an
No, not at all. my lord.
adjournment?
Not at all, my lord. My lord,
That the
unfortunately,
High Court has to wait because you are
unfortunately, my lord, I did not anticipate I would be held up for so long, my lord. I sincerely
sorry.
apologize.
Then why you told your junior?
My lord, I had no other option, my lord. Kindly forgives me, my lord.
Where is the affidavit of service?
My lord, affidavit of service is there, my lord, but on the last occasion, your lordship had mentioned that I should get the injunction order for your lordship's perusal. Unfortunately, my lord, the certified copy has been applied for and obtained, but it's not in hand, my lord. I would leave to file a supplementary affidavit with
Not
the
supplementary. Just show us.
my lord. The certified copy is not.
Show us.
It's not in hand, my lord. Currently.
Show it on the next day.
Yes, my lord.
Yes, call the next. Next.
I am for the petition appellant, my lord. I am praying for not today. My learned senior has not come to today because due to his illness.
Not this week.
No, we kindly fix the matter with earlier twice.
Not this week.
Affidavit of service.
No.
Appellant lordship.
Lordship, in item number 237, Mr. Kushal Chatterjee is appearing for the respondents. I'm praying for a not this week. Yeah, if possible, your lordship be fix this matter on the first week of April, your lordship.
Why?
Because he will not be available in Kolkata.
On the prayer of the respondent, list the matter in the first week of April. Next.
Yes, my lord, I appear to
Give only your name. Yes.
Yes, my lord, I appear, my lord. This is the affidavit of service, my lord. Further, my lord. After having obtained the order.
Matrimonial
Responded, my lord. I am for this.
Yes. This is application for injunction, my lord. That is scan 3, my lord.
Is a FMAT against the injunction, receiver, or what?
FMAT, what happened, the ex parte order, I appeared in the suit, I filed WS, there is a settlement before the Panchayat, my lord, amicable settlement, they will not proceed. Losses wanted to see the settlement before
What is this? It's an application. What is it?
application for injunction, my lord. Not to
Injunction.
sell the,
What is the nature of the injunction you wanted?
my losses can come to page 7.
Which
Of-
application, sir?
Can 3, can 3,
Can 3.
can 3, my lord.
Transferring and or encumbering or
Yeah,
changing the
sale,
nature and
not-
character
Uh,
till the
that
disposal.
is,
What is the nature of the suit?
Suit, my lord, partition,
Suit for partition.
Partition.
Preliminary degree pass.
yes, my lord, preliminary degree passed.
Pass.
My lord.
This appeal is against which order?
Against my orders dated, this is going to come to,
My lord, I am praying opposition to file.
What?
I am praying to
Opposition.
file opposition, my lord.
will file opposition, nahi to?
Oh, this is against an order.
Order dated, my lord, 5th December 2022.
Sir, I can't read. What is this certified copy is supplied by the trial court? I am really surprised. Can anybody read it?
Losses can you see, my lord, last year.
Have you given a typed copy?
No, losses, what copy? Last portion of the, my lord, yeah.
That is what I am reading. I'm just trying to read.
I think, my lord, losses can see the last year. That can be read. Isn't that one, my lord? That one.
This is the order dated 1/2/2012. You are SLing.
5th December 2022.
Oh.
5th
Sorry,
December.
that's my mistake. Oh, order 9 rule 13 dismiss, sir.
Yes, ma'am.
Oh,
Against that, my lord, it was filed and lawsuit dated, it will be FMET. First, it was filed as a FA. Then lawsuit directed the department to change the number. Then number change as a FMET. And I filed one application. Lawsuit said, this is not proper for stay. It is a injunction application I have filed now. That is scan 3.
what is the nature of the decree?
Partition should be preliminary
Oh,
decree.
preliminary decree.
Preliminary decree. That is. And my application under order 9, rule 13 rejected, my lord. That is, there is a settlement before the Furfura Sharif, Gram Panchayat, my lord.
It was not acted upon, sir. That is what the court
Then
has
they have
held.
they have told that I will do everything. You need not to go court.
But your
My client believe it. My
sir,
client believe it.
Your Tadbirkar was taking steps. The court has recorded that.
Anyway,
Even after the settlement, several steps were taken in the suit. Your Tadbirkar was taking steps.
that is my lord, its application and observation.
Why injunction? Suit was also rejected. Sorry. No. Affidavits. 3 week, 2 week, 5 week hence. 3 week opposition, 2 weeks reply. Yes, call the next.
2 weeks, 5 weeks. Of can 3, my lord, of can 3.
Yes, can 3, sir.
In this matter, I am for the applicant.
What is this application, sir?
Injunction.
What is the nature of the suit? What is the
nature of the suit is partition of the building.
You have challenged the preliminary decree.
Applicant number 1 and defendant number 1 is the full brother. And defendant number 1 is the maternal uncle. Jointly, we have purchased maternal uncle.
Again, can you repeat?
Applicant number 1 and defendant number 2.
Applicant number 1, there is only one appellant.
Appellant, yes, sir.
So not one.
Appellant 1.
The sole appellant is there. So appellant and
defendant number 2 are full brother.
Full blood brothers. Say full blood brothers. Then
and defendant number 1 is the maternal uncle.
Maternal uncle.
Yes,
why he has been made a party in a partition suit?
Partition suit, my lord, what happened? The land in question situated in the highway, inside of the highway. Maternal uncle purchased 1 decimal and we
from whom?
The actual landowner.
And
the same owner, we have also purchased 1 decimal. Subsequent amicably, we have constructed 2-story building.
Oh, jointly.
Yes, mine. We are running business in the ground floor, maternal uncle in the first floor. Subsequent dispute arises regarding maintenance of the building, then we have filed the partition suit. That was dismissed by the land court.
Why?
Kindly sit for a moment.
Why it was dismissed? Tell me, you have read it. You will say that what is the ground?
That there is no documentary evidence. We have contributed the building, constructed building.
Oh, then your right also goes.
Yes, yes, my lord. Kindly see the Pradhan also permission granted permission page 30.
Sir, you must have a deed. Sir, you have purchased the property. You must have a deed with you. Your maternal uncle must have also a deed with him. Deed were produced.
Yes, produced yet.
Where is that?
Deed
Which exhibit?
32 page, 22 page deed.
No, which exhibit? Exhibit number?
Yeah.
You are a plaintiff. So must be 1998 deed.
Yes.
That is exhibit 1.
Yes.
Show me that why the court has dismissed. Which portion?
Page 35 minus the ordering portion.
What is the nature of the injunction?
Pardon, my lord.
What is the nature of the injunction you have sought for?
Not to disturb, not to disturb the peaceful position.
Serve the copy and come back, we will pass. Short notice we are giving. Service returnable 2 weeks hence. Don't worry. We'll take care of that. Come after 2 weeks. Immediately effect service today.
My lord, in the meantime.
Sure. To say that what is this Kobala? Yes.
My lord, I appear for the appellants. On the last occasion, the direction was to file a compilation of documents. The compilation of documents is ready. Permit us to file it and kindly fix it.
Well, the appeal has been admitted by your lordship's order dated 6 February 2024. Your lordship was pleased to pass a detailed order with regard to the point of jurisdiction was taken. Your lordship was pleased to negative that. And thereafter, your lordship was pleased to pass the order. Kindly, I don't want to trouble your lordship with the earlier paragraphs. Kindly, my lord, come to the penultimate paragraph. I should say paragraph 26. Paragraph 26 of the order dated 6 February. Both points.
So we have already admitted. Now the question of the application.
Your lordship was pleased to direct, my lord, a compilation.
That is what we wanted because it is against interlocutory order, I believe.
Yeah. No, it is order 21, book 97.
Oh, that's why there are two ways. My personal view is that these type of matters immediately disposed of.
Kindly do it immediately. We are ready to, my lord, to have
immediately disposed of. We don't keep.
Well, the compilation.
It reminds me of the celebrated observation of Sir Vivian Bose.
The trouble started after the decree. Your lordship. Well,
we don't allow. You have to argue.
My lord, the compilation.
You are a third party.
We are the evicted when we are in possession.
My lord, we are the
My
lord, we are the decree holders.
Okay.
Kindly fix it for hearing, my lord, in the first week of
Decree
April.
holder and you are asking for an adjournment.
My lord, I'm led by Mr. S.N. Mukherjee. The compilation just got ready. Mr. Mukherjee, for personal reasons, is not in court today. Kindly fix it anytime first week of April, my lord.
I don't mind that. Only thing is this compilation which has been prepared It did not include, well, kindly see the compilation. Quite a few documents have not been included, which were there in the trial court. And some documents have been included, which were not
there in the trial court. How can you do that? Unless a leave under order 41 rule 27 is given.
These documents are not there, yeah.
My Lord, we have recorded their objections in the contents. We've shown the documents that they've objected to.
Which page?
My Lord, page Roman 4. If you'd see item number 16, 17, 18.
16,
17, 18, 19.
What no objections?
No, we've recorded their objections, my Lord.
What objections? They have not raised, where they raised objections?
My Lord,
These were not tendered in evidence.
That is what I'm asking. Why? I just want to know. This is some unique and innovative way of putting it.
Yes.
I just wanted to understand.
Your Lord.
Nothing. I just wanted to understand. What does it mean?
My Lord, the directions were to file a joint compilation.
Sir, you have written these expressions, inclusion objected by respondent number 1. I just wanted to have a clarity of these expressions. Why you have said so?
My Lord, both the parties were sitting together and preparing the joint compilation.
But this is not a suit where the inspection, discovery, everything is to be done. The question is, once the appeal is filed against a final judgment, then whatever the document which were marked exhibits in the proceeding itself, that documents can only be looked into by the appellate court, will not allow any other documents unless
Order 41.
Very well.
Order 41 rule 27. You have to come within that peripheral of A and B.
My Lord, very well. Allow us to file an order 41 rule
Why do you
27.
allow? That's a statutory.
Yeah,
process
so
why
we
you
file an
allow.
order 41 rule 27.
What for?
My Lord, the documents are...
These documents were produced in the trial court.
No, my Lord, they weren't there in the trial court, and these are extremely relevant documents in the
Why you
interest of...
say that objected to?
Well, these documents have been objected to by us because, well, these were not tendered in evidence. And they...
So, I am not opening my mouth to that because they have to satisfy those grounds of order 41 rule 27. That's why I am not making any observations.
My Lord, we'll do that at the time of hearing, my Lord.
application করবে order 41
Yes.
Justice follow that.
My Lord, we'll file an order 41 rule 27, and we can argue that at the time of hearing.
We can't say anything whether to file or not to file.
Kindly fix it for hearing, my Lord. And
It is fixed for hearing today in terms of this order. Do it.
my Lord, the paper books just got ready, my Lord, and Mr. Mukherjee is not available for personal reasons, my Lord.
Your Lordship will kindly, my Lord, keep it on all the day in the meantime, whatever steps they want to take. But my Lord, these documents should not be there in the fixed paper book unless your Lordship allows them.
An accommodation is sought by the appellant on the ground that the senior counsel is indisposed. Should I write indisposed or say has gone out and not available in the town?
No, my Lord, it's actually very serious personal issue. That's why, my Lord.
Indisposed.
He is not come. That is good enough for me, at least. I don't know about your Lord.
Stop. In such view of the matter, let this matter be listed when? When?
My Lord, 2nd April. 2nd April.
5th April.
My Lord, could you do it 1st April, my Lord? Is it possible then? My Lord, then the week after.
5th April.
My Lord, the week after that, my Lord.
5th April.
Mr. Mukherjee is not there on the 4th and 5th April, my Lord. Just any day prior or after that, my Lord.
My Lord, can you make it, my Lord, 12th? On Thursday, your Lordship take up this matter or any day.
My Lord, I request you to not make it on 5th April.
Can you make it 11th April? Oh, 11 ছুটি।
There's no holiday recorded.
কোথায় 11 ছুটি?
There's no holiday recorded.
No holiday.
In our calendar.
Mr. Devnath Ghosh is asking for, but declaring a holiday by himself. There is no holiday. কোথায় কি ছুটি? সেটা আছে লাল আছে।
লাল আছে বলি আমি বলছি স্যার।
ছবি মিটে দিয়েছি ওটা আমি জানি। হ্যাঁ আছে। তাই 11 কোনো দেখা কোনো ছুটি নেই,
কিন্তু এখানে লাল দিয়ে বসে আছে আমাদের।
এখানে আপনাদের নেই না? যে যার পারে প্রিন্ট করে বসে আছে
তাই লাল।
তিনটেতেই লাল আছে আমার কাছে তিনটে। No, there is no holiday alert in your lordship's calendar. But my lord, we have got holiday in there.
For everybody's not only for the judges' calendar. No, it is for everybody's calendar.
But we have got red, my lord. 11th, my learned friend is right. Surprising.
Why?
Why?
They can do it.
Should you just look? Everyone was in
Calendar code to it is
April 11th red, April 11th red. Three different.
He became very happy when I think that Thursday on.
At holiday day. Well, keep it on any day convenient to your lordship.
16.
I'm obliged, my lord. Grateful. Grateful.
But LCR has not been called for by your lordship. Is it necessary?
Don't use the word LCR now.
It's not to be.
That is correct.
Very well, my lord. ECR, trial court report. Yeah, I think that is the correct. Well, I quite agree, my lord. That is the correct term. Of course, it's the trial court. I don't know LCR word that's been used all throughout, my lord.
Recently,
I think it's absolutely correct.
The observation has come that of the CGI, don't use those subordinate courts for the lower.
I think
so. Lower court records should also not be used.
Trial court. ECR. I stand corrected. What has happened is this, my lord, long years of practice were completely ingrained into our mind. That is the problem.
What about the constitutional provision which uses those words?
I surrender to what has fallen from your lordships. I don't want to get into that.
Yes. No, that's the bit. Why we will say lower court or a
No. Sure.
What is it for? I also is a very ardent.
There is something I stand corrected, and my lord, I will not forget.
I have seen that whenever in 227 also, when there is the time fixed disposal of the matter when it comes, you have moved many 227 applications.
No, but I always say trial court.
Oh, you have moved. Yes, I never use the word. I hereby direct the district court to dispose of it. I always said I request to dispose of it. Never do that. Never. Any of the order you will not find direction.
Shall I tell you, lordship, very frankly? We object from this side of the bar when we find a direction to that effect from the Supreme Court to your lordships. We say that this should not be done. So, my lord,
no comments.
Your lordships are not able to make comments, but we can perhaps. That amount of liberty we have here. Very.
Grateful, my lord.
Sit down.
brother 20, the defendant. One. I mean, this is my application for stay. Milord, picked. Yes.
The cost taken of the instant appeal reflects that the defendant number 2 of the trial court has read his last will in the frequency of the suit, and that had been duly substituted by his heirs in the trial court wide on the number. And defendant number? What is this cost title? Rabindranath Bidai, since deceased, his legal heirs. It's like that.
No.
No, died but not reflected in the degree.
Degree. Milord, yes, degree Milord has not been corrected.
Maybe sent out.
I am talking about the cost titles.
Of the memorandum of appeal.
Yes.
Milord.
How you have described?
Gurupada Bindai is the defendant number 1.
No, Rabindranath Bindai. His heirs are already substituted.
Already.
How can you?
No. Then Milord, the date person cannot be on record.
Then who is the advocate on record? Who is the advocate on record?
Just new entrant Milord started.
Who told you to do that? I know who told you. I wanted that. Who told you? Advised you to do like this?
No.
Tell her.
Senior, your lordship.
Who? I anticipated that. It's not that I did not. For that reason, I wanted that. What are you teaching them?
No,
you are a veteran. You're a seasoned lawyer practicing for a pretty long time. Is this a way to groom them?
No, the date person cannot be. Leave me correction.
Anyhow,
leave me. Kindly gives us leave, we will correct it.
That we will grant you a leave. What is the application?
Milord, this is Milord, stay of Milord. We are challenging the preliminary decree in a partition suit, Milord.
Stay.
Milord, final decree has not been Milord levied. That's why Milord. Otherwise, I could have said, Milord, let it go on. No final decree shall be drawn up till disposal of the appeal. But it has not been, Milord. Not been. Final decree has not been.
So what? Stay of the decree.
Stay, Milord.
Decree.
Milord, the final decree has not. They have not taken any. Plaintiffs have till date not taken any steps, Milord, for putting the decree into execution. No appointment. Final decree appointment has also been not done.
Let him proceed with the appointment.
No, they haven't. Plaintiffs have not filed yet. That's the.
Let them proceed. The instant application is sorry, Lako. The instant application is filed assailing the preliminary decree passed in a partition suit. So the application has been taken out.
Proceed korbe, no final decree.
Taking a stay of the operation of the preliminary decree pending the instant appeal. Yeah. It is submitted by the learned advocate for the appellant that after the preliminary decree is passed by the trial court, steps has not been taken by the plaintiff respondent. In furtherance of the preliminary decree. We do not feel that the court should stay the operation of the preliminary decree simply because a statutory right is created. The statutory right of appeal is created in favor of an aggrieved person. There is no fetter on the part of the court to pass a further preliminary decree or modify or alter the preliminary decree because of the special character and nature of the suit for partition. Full stop. In such view of the matter, we do not find any grounds to stay the operation of the preliminary decree. However, we feel that in the event the final decree is passed, it may have some ramification on the instant appeal and may cause irreparable loss and injury to the petitioner, and therefore we dispose of the instant appeal with the following directions. One, in the event the steps are taken for appointment of the partition commissioner, the trial court shall proceed to decide the said application, irrespective of the fact that the instant appeal is pending before this court. Next, in the event the partition commissioner is appointed, the commission work shall continue, and the report may be filed by the commissioner within the time as may be directed by the trial court. 3. Any objections to the commissioner's report by any of the parties to the proceeding shall be decided, but no final order granting the final decree, final decree shall be passed until the disposal of the instant appeal.
The commissioner's report shall also not be accepted, my lord.
He says that the objection will be made, but no final decree shall be passed.
One thing, my lord, perhaps my lord, the decree has to be sent down for correction, my lord.
Nothing. Either.
LCR paper book notice of appeal. ওগুলো দিল তো LCR পেপার না অ্যাপ্লিকেশন ডিসপোজাল LCR পেপার বুক ওইগুলো স্পেশাল নো মিলার ফার্স্ট টাইম
Sir, I just thought that anyhow, it's
LCR paper book, Milord, those are.
But the application cannot be disposed of in their presence, in their absence.
I may expedite the appeal, Milord.
We can't pass this order in their absence.
There is no further, Milord. Nothing more remains in this application, at least.
I know, but no final decree shall be drawn up for a period of 12 weeks from date or until further order, and then serve the copy returnable after 2 weeks.
Service returnable.
Yes. Hey, Prathama Lakho. Yes. Sure. Leave is granted to correct the cost title of the memorandum of appeal here and now.
ওর নামটা কেটে দেবে with the leave granted by honorable court বলে ও সই করে দেবে
Yes. Rearrange those 2 kho, everybody should be 2, 3, 4, 5, 6. Rearrange them like that.
My lord, I appear on behalf of the appellant. Lord, I appear on behalf of the appellant, my lord. Lord, there are,
What is this defect?
my lord, there are,
Defect has been cured.
yes, my lord, the defect has been cured. My lord, there are few applications which have been pending, my lord. Can 1 is a restoration application. Can 2 is a condonation of the appeal, my lord. The appeal was dismissed for default.
Why? Why?
For
The
default.
hearing stage.
My lord, not at the hearing stage, my lord, after admission. After admission in 2021, 248.
FME is directed against what?
My lord, the appeal is directed against an order dismissing the suit. It's a partition suit, my lord, filed by the
suit.
My lord, it's a partition suit filed by the appellant.
Missing a suit under what provision?
Order 7, Rule 11D.
I find from one of the order it is a partition suit.
Yes, my lord. That is the
Order 7 Rule 11. Why
yes,
partition?
my lord. That is my lord. There was a deed of settlement. My lord, but before your lordship goes on the merits, my lord, it is my duty to point out, my lord, this appeal had come up before your lordships in October, when your lordships had directed us to communicate to the erstwhile advocate on record of the appellants to be present in court, because your lordships
Certain
found
allegations have been aspersions
your
have been
lordships
made against him.
your lordships found that certain
That is my principle. That
yes,
they
my lord.
should
So
be heard.
that is exactly, my lord. We have served the notice, and we have also personally, my lord, approached the advocate, learned advocate, and informed the learned advocate about what fell from your lordships, my lord. My lord,
Who is that advocate?
my lord, may I give the notice?
Tell him to come at 2.
My lord, may
Tell
I?
him to come at 2.
My lord, that I shall do, my lord. My lord, may I just?
No, nothing.
My lord, because perhaps, my lord, on the first day when the appeal was moved before your lordships, my lord, if your lordship just gives me 2 minutes to satisfy your lordship that there is no allegation against the advocate, my lord.
We will not tell him to appear.
Can I be excused to like what a fixed matter?
No, to
2 PM a fixed matter is already there.
tell him.
Thank you, Lord.
My lord, we shall inform the.
Yes. Send any of your junior or anybody. You know the restoration fate. You are quite conscious of the fate of the restoration.
I think the section 5 applications.
Whatever.
Thank you,
So
Lord.
let him come.
Deeply obliged.
Maybe it was. এই নামটা সবসময় ভুল হয় গৌরব নামটা কিন্তু নেই আমরা এনওসি আছে অভিরূপ ভট্টাচার্য লিখে দিয়েছি লিখে দিয়েছি এই ওর উপর লিখো না
Yes, what is
the suit for partition that dismissed is a plaintiff's appeal
on the ground?
Now our your losses see the last order. Initially there is an order, ad interim order, passed by the Honorable Justice I.P. Mukherjee and Vishnu Chaudhary. There are on many your losses heard this matter. The last occasion, your I filed a supplementary during after the suit was dismissed. The respondent one of the co-sharers, he made some construction. Then your lordship was whether your lordship wanted to appoint a special officer. Whether my client can bear the cost of the fees of the special officer or not. I have talked to my client. He agrees. So he will visit.
No, that cannot be a ground whether he can.
Oh, that's fine from your lordship.
The moment he has engaged you, we were absolutely sure that he will bear.
Then I find
if he can bear the burden of Mr. Botchas, then bear the burden of the special officer.
Then we filed an injunction was obtained But that has been expired. The injunction, I got an intimate of injunction. But that was obtained on 26 March, June 2023. They are not an identity order. They never appeared. I served notices. They never appeared. None of the respondents appeared. Now my clients, none of the is a 50% of the owner of the suit property.
Now there is a construction going on or no construction going on?
Now they are not making any construction, but that has already been, some iron gate has been, the shutter gate has been installed, such and such. Because there is no injunction. Suit for partition has been dismissed.
No, those have been installed after this order or before this order? Order
No,
of
after, no, before this order, before identity order. The suit of 2017.
So we are disposing of the application, making this order. What more?
Then you also can give some protection to my clients, my lord.
This protection has already been given.
But some more protection, what are the not?
What more protection?
In a major construction, or any type of construction, major construction. What is it? Not construct and major construction under.
Obviously, there is some kind of a, the repairs. There is a crack which has developed.
The shutter, fixing the shutter. If he blocks my entrance, that is the major, not major construction that may save the other side. It is not a major construction. That, but any type of construction, not to change the nature and character of the property. That usually you get
Whether you were enjoying an interim order in the suit?
No. No. In the trial court, I inquired for my client yesterday also. No.
Yeah.
But for the first time, I got the injunction from the court.
Why? Simply because
only construction.
Your client has filed an appeal. So
He's not able to. He's a 50% owner. Other the sisters, they gifted the property to him. He's not being able to live there also. Can you give some protection? But Lord for record may be qualified at my own cost.
Where is the property?
Asansol. Asansol.
Who lives in Asansol? Anybody who has a house in Asansol?
Asansol, no.
Any junior member of the bar?
No, I shall come back when at 2. I shall inquire who is the residents of Asansol.
Tell us, any junior member having
yes.
at least 3 or 4 years of practice?
3 or 4 years. Okay.
For this purpose, they are the best person.
Yes, only. My client told me, but some money fee, there's a fees is something. Otherwise, I am retired person. That will be trouble for me also. He's a retired person.
If he does not feel any trouble by engaging you, then he will not feel any trouble for this.
No, you also knows I am not type of lawyer, you know.
Yes.
Initially, I was not there.
No, I know what I know. You say not that type of lawyer. I know what type of lawyer, so no difficulty. Afford. If he can afford, then he.
No. I cannot. Otherwise, I shall ask my friends.
Well, I will respond to.
My application. Well, this is this application, my lord, for the drawing up of a degree, my lord.
This is my opposition.
What opposition?
This is
The
a
drawing up of a decree. It's a
because the
ministerial
history-
work of
the
the court.
history was judgment of 1989.
What opposition? We have to just look at the decree and then say that what.
This point has been its third time attempt. It has been already decided by. Madam.
Sorry, we will see all the records. Opposition.
Also, no, I brought it.
No, you should
All
not.
documents, all documents is here.
But it means that was filed in the proceeding,
Yes.
not opposition for the first time.
No. This is all documents.
My
I mean, what only to
He has filed opposition, my lord, to this application for drawing up of a decree which he wants to.
Opposition you are filing.
all documents, nothing more, all documents, which are required. You shall see. This is there. This opportunity there. Can you see, my lord? There's a degree of judgment along this back. The
My lord, first, my lord, may kindly go through the judgment and decree.
Make an application under
Well,
151.
before hearing him, my lord, may kindly, my lord.
Send it to our chamber. We will go through the judgment and then we'll say that what is
These are fine.
not necessary.
So this is necessary, but otherwise you penalize me. These are all documents necessary.
Sir, you can say that I'm giving a compilation of those documents, but it can't be in the form of an affidavit in opposition.
I give
The drawing up of the decree is a job or the exercise to be done by the department.
No, why? This is the department can't do it because has not done. I show. Just a minute. Oh,
For your ceremonial purpose. It's nothing.
What happened? Can you see why? This judgment decree was passed by the division bench. They could not draw the proceeding. Then they make an application under 151 for amendment or incorporation of documents. That was rejected. Then they went to the Supreme Court. That Supreme Court rejected after civil appeal. Then again they make an application. That was rejected the third time.
Sorry, they wanted an alteration or amendment in the judgments. That was rejected. That is now the judgment is there. We have to just look at the judgment and then see what
They made for the drawing of the
Anyhow,
law.
Send the file to our
So your
chamber.
Lord,
We'll
can
see
you-
to it.
Or your Lord can give me the liberty. I just file a compilation
Compilation you give.
by tomorrow. My lord.
By tomorrow you give compilation. So only opposition.
To my lord, same my lord, but they related to the same decree, my lord.
Both are the same.
Yes, we'll see to it. Then
There is direction. I will start as a direction. I will.
who passed the directions?
That's the Banda.
My lord, my prayer is, my lord, against the department for drawing up of a decree, and I have shown.
Let us first go through the order and the judgment will see to it.
Grateful, my lord.
If we find that something is more required, then we will definitely revert back. to you.
Well, there's a directions for only.
Whatever, you just
You
keep
can
it.
give it the direction to file the compilation by tomorrow.
Please file a compilation so that the next week the holidays are coming. We will go through. Don't worry, you will just give it.
Tomorrow I'll do.
Yes.
I'll give liberty tomorrow. I'll file.
Grateful, my lord.
Yes.
Well, I'm not filing the affidavits in reply.
No.
Grateful.
Yes. Yes.
249. Well, I did not find anybody, but Swapon Mukherjee. I searched Mr. Swapon Mukherjee. He can tell me. But Swapani today, but I did not.
Come on the next day.
Next day. Next day, not tomorrow, Malad. Tomorrow I shall not be here.
Yes. Call 250.
Malad, I'm for the appellants. This is my restoration application.
Have you served? Have you served?
Malad, I don't have the service.
Then
proof of
service 2 weeks hence. Serve the copy and come back after 2 weeks.
Much.
My lord, I'm for the appellant.
Is the matrimonial or what?
Matrimonial.
Matrimonial.
Registered administration, yes, madam. There was an order of registered administration, madam. Lojima, madam, registered Lojima. That effect has been subsequently removed.
The matter has wrongly appeared under the heading application. Stop. Let this matter be listed under the heading order 41. Rule 11 of the Code of Procedure.
Yes,
Immediately.
immediately.
Now, in the next week.
Next week. এই নাম দিচ্ছি নামটা দিন কেন স্যার এই নাম আমি দিচ্ছি
What is the defect? Ricky?
Lord, the advocate on record did not come today, my lord.
Just give me. মাইকটা দাও বললাম একবার seen the note of the stamp reporter. So it is indicated that the date of application for certified copy of the impugned judge even impugned judgment and decree needs correction. It is further indicated that the report on the limitation could not be furnished unless the correction is made by the court below. In such view of the matter, let the file let the certified copy of the impugned judgment and decree be sent down to the trial court for correction. The office shall take immediate steps in this regard. And the trial court shall also ensure that the necessary correction is made and the certified copy of the judgment decree is resent to this court before the next date of listing. Let this matter be listed 3 weeks hence, or 4 weeks hence. Yes. to them. Since the litigant would suffer the most because of such lapses having perceived in course of the hearing, we hereby extend the and available right would be uh, would be destroyed. We therefore extend the time for a period of 2 weeks from date, subject to the payment of cost assessed at 5,000 rupees. Stop. The said amount shall be deposited within a week from date with the state legal services authorities, West Bengal. And on such deposit, the said authority shall keep the said amount in an account earmarked for juvenile. List the application after 2 weeks.
Much obliged, ma'am.
May it please your lordship. Now, pursuant to your lordship direction, the copy of the application with the supplementary had been sent for service. And postal report says that they had been served. Madam, I served this one. Served the learned advocate as well as the petitioner. Madam,
Short form. It's A. Somebody short name.
Madam, subsequently, after affirmation of that revenue service, I received back the postal document received by the opposite party. Madam, I received, my lord.
How is it possible?
This is what everything is possible now. It is, madam. Refused.
What is the matter about?
Matter is, my lord, the petition before lordship, my lord, had purchased the land by making payment rupee 1,70,000 to the opposite party. He received the money and delivered the possession. Received the money on 2 dates, and he affirmed an affidavit. Subsequently, my lord, that document of affirmation was sought to be snatched away, for which the petitioner made a complaint to the police station. That I have annexed to the affidavit, supplementary affidavit, my lord. But I have prayed for, I am in possession. Still then, my lord, he is trying to create third-party interest. My lord, I have come before lordship, I have lost the suit before the court below, my lord. I have filed an application for stay.
What is that suit?
Suit for specific performance.
But that has been dismissed ex
Exactly.
parte.
Yes, yes, ma'am.
So what was the date of? What was the date of an agreement?
My lord, date of agreement, my lord. That is dated, my lord.
Amendment.
My lord, he affidavit, my lord, the file an affidavit, my lord, made an affidavit. The court of my lord, that is annexed, my lord. My lord, he took the money on 24th of February 2015 and affirmed an affidavit on the same day on 24th.
Where is the affidavit?
No, that is in the court below, my lord. That copy is not with me.
Showing that it has been for the purpose of sale of the property. So that itself. But the trial court says that not a single document you have produced.
My lord, that is the only document available to my client, the affidavit. So
Nothing. We have seen exhibit 1 is the LRROR. Exhibit 2 is the airship certificate by Panchayat. Oh, this is original money receipts 3 and 4.
Yes, yes, ma'am. That is the only document.
Where is the affidavit? This is original money receipt. Can be proved orally and it can. On the strength of oral agreement for sale cannot be forced. Oral agreement.
Well, may I hand it over to others?
But this was not produced before the trial court.
This was the part of the plaint, my lord.
No, but you did not tender it. It's the original money receipt. But this is an affidavit.
he affirmed that no receipt was granted, but he affirmed an affidavit affirming that he has received the money and delivered the possession.
2015.
He took the money and delivered the possession, and that is the affidavit, madam.
Jail number such and such, Khatiyar number such and such, Tag number such and such, Potito. Means the area is 0.1 shota. And 218 by 8 by 4. Again, Poriman Boston lives there. Exigeny points 1 second. Such and such. Such and such, set of such and such is in position of that. One water, such and such. Simply, such and such. After the death of my father, occupying that. My mother also expired. But our mother also played something after the death of my mother, I acquired 1/3 share and then I occupying and possessing this. One-third not sure. Shatak Bikroy to river to contemplative or to sell. Janaile means I have shown to say Muhammad Rafiqul must be that is his thing. Sheikh Muhammad Islam Sheikh Muhammad Rafiqul Islam अनुमानिक बाजार को 1,70,000 में क्रय করিতে ইচ্ছুক হইলে selling this property at 1,70,000 আমি রেজিস্ট্রি করার পূর্বে টাকার খুব প্রয়োজন তো 8.7 I have agreed to sell it to Muhammad Islam, whatever, at 1,70,000. And since I needed money for this, so I have given up my position. Say, and I am residing in my shop as a permanent resident. তো টাকা আমার চিকিৎসা বা ব্যবসার কাজে ব্যবহার করি medical expenses and the business. তাই মুসলিম ছায়া পরিয় বিমান আমাদের বিক্রয় করতে আর বলতে নাকি पैसे को बिजनेस के लिए यूज करूंगा इसीलिए मुस्लिम शरीयत के हिसाब से जो है विमान मुस्लिम ইহাতে মানে after therefore আমার বাড়ি সম্পর্কে thus I'm myself or my not equally আপনি তো তাহা আইনত বর্তমান if an objection is made that will not be considered legal and by the gospel Sir, was it marked exhibit? I have doubts. But he's saying original money. That receipt is filed, not this. Sir, we can't say. This can't be, this is not a receipt.
That is the only document I have.
No, I do not know whether you have produced.
And your
this
lordship can
document
call
or-
for the records. The records, the original document is there. I filed the document, original document, go to the court below.
And secondly, you can't protect your position.
Well, I am in possession. There is no dispute.
But you can't get an injunction to protect the position.
Well, I am praying so that third party interest may not be created. That's a prayer. That protection, your lordship.
Was there any injunction during the pendency of the suit?
No.
No.
No, my lord. But that protection I am praying before your lordship, my lord, so that no third party interest may not be created. That's the only prayer I am making before your lordship, my lord.
We are calling for the lower court record. Yes. The court, the trial court dismissed the suit for specific performance of an agreement. Apart from other grounds, that the plaintiff have not produced a single scrap of paper to show that the money which he lent to the respondent pertains to a sale of the property described in the schedule appended to the plate. Our attention is drawn to affidavit allegedly affirmed by the respondent, but we do not correlate the said document with the list of exhibits incorporated in the impugned judgment. So, in order to eradicate such confusion, we feel that the lower court record may be brought. That the record of the trial court is necessary. We therefore direct the trial court record be called for through special messenger at the cost of the appellant. Such cost shall be put in by tomorrow. The office shall ensure that the trial court record reaches to this court on or before the next date of listing. List the matter on 4th April. Oh, put it let the affidavit of service filed today be kept on record. Though the downloaded information from the official website of the India Post indicates that the postal article has been served upon the respondent, but the counsel for the appellant submits that after the affirmation, he received the postal article containing the instant application, wherefrom it appears that the respondent refused to accept the service. In view of such a discrepancy, initially we felt that the further service is required to be effected, but after perusing the postal article returned to the appellant, wherein the postal peon has made an endorsement within bracket refuse, we therefore accept such service to be efficient. Take back this. We therefore accept that the service has been effected upon the respondents.
May I get your lordship's order today, my lord, so that download?
Sir, it is open in the open court, dictated so loudly.
So that may
Nothing
they accept it.
They will accept.
That's the happening.
Yes.
My lord, on the last occasion, my lord, all the substitution, all this has been done. I believe the substituted respondent has also been appeared. Now, subject to approval by your lordship, injunction application is now left out. I understand the record has already, my lord,
arrived.
received. Kindly direct to tag with this, my lord.
Add with this, there must be endorsement that the record has arrived.
No. It is reported they have taken.
How they know?
One of your lordship
record
can record our submission and direct the department to tag with that it has been submitted on behalf of the appellant. That the record has already, lower court record has already arrived.
No, we don't find.
It's not yet examined.
But because record, the High Court record, endorsement file was here. How it will be endorsed by this time? Because all through this file was pending here. Naturally, examine of if your lordship can take it and by the direct.
Let the file be sent down in the department for the purpose of the information as to whether the lower court record has arrived to this court or not.
If so, right?
This is the matter after 2 weeks.
And my lord, I believe all so you are appearing. Well, kindly record.
After 2 weeks, we have said file wo galat. Yes. All the next 261.
Sure. No, नामটা দিয়ে দাও।
Your client uses both the surnames, Banerjee and Mukherjee. Yes.
Yes. I'm the plaintiff, my lord. This is my application for expeditious hearing of the appeal. My suit has been dismissed, my lord. There is no scope for any interim order. My lord, this is under 2G of the West Bengal Premises Tenancy Act, not City Board.
Where is 13,840 rupees? Where?
ভাই এটা ছেঁড়া আছে গ্রিপসের পেমেন্ট
It has been, my lord, online, my lord. It has been paid, my lord. Transfer.
হ্যাঁ এই কোথায় ডিপোজিট করেছো গ্রিপস না না এইভাবেই নিতে এই তো তারপর হাইকোর্টের এই acknowledgement মানে এটা পেমেন্ট এটা রিসিট এই তো মামলার নম্বর
The deficit court fee of rupees 13,840 has been put in on 21st August 2023. Let the acknowledgement
I have a better copy দিয়ে দেবো
downloaded from the official website of this court be taken on record. The staff reporter is directed to give a revised report on the court fees immediate. Now, expeditious disposal, lower court record, trial court record, special messenger, how soon?
1 week, special messenger cost.
By 28th.
By 28th.
By 28th. Then requisites by 28th.
On by.
Yeah. Paper book 4 weeks from the date of service of notice of arrival of record. Liberty to mention. After filing of the paper.
4 weeks from the arrival of.
Yes.
Great. Can dispose.
Grateful, Your Lord.
পেপার বুক করে আবার দেখা হবে
হ্যাঁ করে
Lordship, I appear on behalf of the appellant. Your Lordship, I need to carry out a substitution application since now Twitter Inc. has been taken up by X Corp. So, Your Lordship, since Your Lordship, the appellant, which is Twitter Inc., has now been taken up by X Corp, by a company called X Corp. Now it's called X. So, Lordship, I need to carry out a substitution application. The substitution application is here. It's just I'm only awaiting the wakalatnama. So, if Your Lordship kindly grants me.
Not today.
Grateful. Lordship.
My lord, I appear for the appellant and pray for recalling the.
Have you served the copy?
No, lordship.
Let's serve. Come back.
Lordship, lordship.
Come back. Service, 2 weeks, short service. We are giving a short time. 2 weeks.
Sir, the advocate appeared for condonation of delay.
No, on the party.
Oh, lordship.
Sir. Appearance after 2 weeks. Yes.
Grateful.
My Lord, I beg to appear for the plaintiff appellant. My Lord, due to laches on our part, my Lord, the deficit court fee had not been paid.
But it's a restoration.
Yes, the deficit court fee had not been paid, and at the order.
Why it is not paid?
My Lord, 4,880, my Lord, we ought to have paid.
And with the further cost for extension is 5,000 rupees. Pay.
Lord would kindly, my Lord, on the day the order was passed, my Lord, we had not been present and we had also not put in the court fee.
You will have to put in the court fee.
Yes, we will have to put in the court fee. My Lord would kindly direct us to pay the court fee, my Lord.
Deficit court fee. So big. It was dismissed for default.
No, on account that we didn't pay the court fee as well as we didn't appear. Both.
What is that? Where is that order?
Your Lordship kindly takes
There is no necessity unless you put in the deficit court fee, we will not accept this order.
yes, my lord. Then kindly
No,
direct.
we will not extend any order. The dismissal we will not extend. It is of your own you have to pay.
Difficulty is this, my lord. Today the appeal is dismissed. So court fee, my lord, how can I pay now, my lord? That is the difficulty. My lord would kindly directs me to pay the court fee, my lord. I'll paying it immediately. Difficulties is the appeal is not in existence. How can I pay the court fee now?
A registrar writing it. Registrar writing. Just pass over. Let it. Let's call the next. I'm for the You are for the appellant. Come on the appellant side. I just thought that you are for the respondent.
I'm sorry, Lord. I just missed, Lord.
The junior is not assisting you properly.
Lord, it was my mistake. I did not see them, Lord. The card that was in. But I'm challenging, Lord. A letters of administration which was, Lord, ordered on the basis of my alleged admission in the cross-examination. But I am a rustic lady. The learned judge passed, Lord, this order granting letters of administration on the basis of letters of administration, probate. Stating that on an application by
What interlocutory injunction or whatever the
but I'm praying, Lord, since the letters of administration has been granted, Lord, I was praying for Lord not to alienate Lord, the property Lord, by the holders of the letters of administration, the opposite parties.
Your objection was turned down on the only on the ground of admission.
But the judge has recorded that it was my statement at the time of Lord cross-examination within inverted comma. I have no objection if the petitioners of this case get decree according to their prayer. This was written down in English. She doesn't know English, although she has put her signature. Other side took out an application based on this statement under Order 12, Rule 6 to say that there is an admission in our favor. So kindly pass an order. I filed an objection saying that I am a rustic lady. I did not understand the import of what I had said. Therefore, I have never consented. I had filed a written objection to the grant. The learned judge said, no, this is an admission. I grant letters of administration on the basis of what you have stated in your cross-examination.
Have you served?
Lordship.
Have you served?
No, Lord, there was no direction. This is coming for the first time.
There is an allegation that they are immediately contemplating.
But if your Lordship.
It should be. It should be unconditional.
দেখালি লাগিয়েছিস
Sir, there is nothing you have stated in your petition regarding this.
Lord, I have got the copies, Lord, of the objection to Order 12, Rule 6.
No. In the injunction, we are now taking up the application.
Lord,
You have asked for vacation at the interlocutory stage. You want a
Lord,
entire order to be
paragraph 24, Lord, if I'm not wrong, Lord.
Yes.
Paragraph 24, page 10.
What?
Lord, that learned court will have failed to consider and appreciate that said Uttara Sarkar Mondol.
No. What interim order we are thinking?
Lord, interim order, Lord, yes. Your Lord,
Nothing.
Lord,
No averment. Injunction, as you said, not to deal with.
Lord,
There is nothing. There is not a single averment in the application that they are attempting. Show us not a single averment. What type of an application is this?
This is Lord.
Sorry, service 2 weeks. Come.
But kindly, Lord.
No.
But it was not.
It will be a greater injustice if it is done. No. There must be some averment, something which was there. No. Service 2 weeks. Next.
But kindly grant us, Lord, liberty to amend. But this is a change brief, Lord. But kindly grant us a liberty, Lord, to file a supplementary, Lord, to this.
You come first, you serve, then come back, then we'll see to it. Yes, next.
And grateful.
266.
66, Mr. Devasis Roy is appearing. He has not come to court on personal reason.
It's not today. 267.
And for the respondent, Your Lordship.
Pass over what can be done.
And for the respondent.
Any of pass over next.
Your Lordship, in this matter, Mr. Shomo Mojumdar and Mr. Syed Nurul Arifin for the appellant, they're engaged in courtroom number 13, Your Lordship. Kindly pass it over.
Pass over.
Yes. Same prayer.
71.
My Lord, in this matter, I am appearing led by Mr. Devasis Roy. Due to his personal difficulty, he has not come today, my Lord.
Today?
Not. Grateful, my
73, Lordship. In this matter, Mr. Partho Pratim Rai is appearing, Lordship, on behalf of the appellant, Lordship.
What is this can one?
Can one, Lordship, for stay, Lordship, of the operation of the order, Lordship.
What is the nature of the order?
Injunction order,
Definitely
Lordship, in
injunction.
terms of status quo,
My
Lordship.
own judgment is staring at your face.
Now, Lordship,
Never. Tell me I am wrong. I am ready to accept that I am wrong. Tell me. Surveys come after 2 weeks. Yes, next.
No, no.
Honorable kindly adjourn the Yes, yes, yes. Then my lord would kindly adjourn sick for 2 weeks, but I will come. And we are looking into this system. If the system can be, the refurbished or something, and come with the physical goods. And thereafter, is the hard copy. Don't worry, we'll accept it and then. But in the long term, my lord, something needs to. That is what we are inquiring. Store. System. Save the
or I'm requested on behalf of the appellant to speak, not today, ma'am.
Upon the appellant side, I just thought that you are for the respondent.
No.
Not today.
Not. 76, my lord, I am for the appellant petition, I am seeking direction for service. Section 5 is there.
That one is the section 5.
Section 5.
Service 2 weeks, 3 weeks.
Yes, 2 weeks. 2 weeks, 2 weeks, my lord.
Yes.
And for the petitioner,
for the respondent, I have been instructed to appear for the respondent.
Partition suit.
No, my lord, the suit, my lord, for eviction, my lord, which has been decreed against him. Praying for stay of execution.
While your the execution has been put.
Yes. They are proceeding. My lord, writ of delivery of possession has already been issued.
Writ of delivery of possession already issued. Section 5.
Section 5 is there, my lord.
No copy has been sought.
There was no caveat, my lord.
No, I am not the caveat.
My lord, I am immediately giving.
No,
immediately.
Order come on Thursday. We can't pass an interim order in view of order 41.38. W3.
And I'm supplying the copy here.
Sir, the copy. Come back on Thursday. Next.
For the
সেই রিপোর্ট আছে ডিফেক্টিভ রিপোর্ট আছে নিশ্চয় হ্যাঁ
For the respondent, yes.
Respondent number 1.
Where is out of time, section 5.
Yes.
Kaushik Modak.
Appearing for a pretty long time or first time?
No, it was there for last 1 week only, not
Passover there.
To 79, I appeared for the appellant. This is my affidavit of service, Lordship. Lordship, it is a prayer for injunction because my temporary injunction application has been rejected.
Rejected. You were enjoying any ad interim order?
Yes, Lordship. I was enjoying the ad
What form?
for not raising any construction and not to also to alienate the property, Lordship. I was enjoying it.
What was the suit? What is the suit for?
Partition and injunction.
Partition and injunction.
Lordship, the
They make a construction.
Lordship, Lordship will kindly take up my injunction application, Lordship. They're not only making construction, they're making construction, permanent construction in such a way that there is no space in between, and also there is a electric tower was there. Now I am not getting electric connection also because of that. They have disconnected my lines. I am one of the heirs of my
How can they disconnect your line?
No, Lordship, the way they are raising construction, there is two brothers. Originally, there are two brothers. I'm the heirs from one brother. These are LOP plots, Lordship, from the Refugee Rehabilitation Department. Two plots were given side by side to two brothers. The plaintiffs as well as the defenders are the legal heirs of one of the brothers. Now, the adjacent plot, which was my uncle's plot, was also there, and there was a transformer. Now my brother who is raising the construction, they are encroaching this portion of the uncle's plot also, and also
You have nothing to do so far as the uncle's plot is
concerned, but
you are concerned with
they
your
are
plot.
raising aerial constructions, and also within the plot in which I am seeking partition and injunction, Lordship. There has been partition in there has been construction in such a way that there is no right to passage also. Lordship will kindly take up my injunction application, Lordship.
Why the trial court refused?
The trial court has refused, Lordship, on the understanding of my prayer that my submission was that I am the brother who had suffered an injury. I am I have very limited means. My other brothers are well settled and they are with good financial means. It was the agreement between the brothers amicably that they will construct an area, my property, in the somewhere in the middle portion, and that is why they have raised, two of the brothers have their constructions through which I was having a right of passage, and I am now residing in a very temporarily constructed manner with a tin shed at the back of the suit plot. Now, after there has been, that was my submission, that is the portion where they had promised, but that was not my prayer, that I want injunction because I want construction on that portion only. That was a contention, that was a submission, that this was the agreement between the brothers, that since I have limited means, I have suffered an accident, I don't have financial means, they will give me that portion, and that was the arrangement. Pursuant to which I had lodged some complaints before the municipality that I have withdrawn, but subsequently they did not keep their commitment, and now they are raising constructions in a manner where I am not even able to reach the property, the back portion of the suit plot where now I am presently residing. That was the contention. Learned trial court most respectfully misunderstood my.
Was there any commission?
No, Lordship. That was one ground on which the prayer has been rejected, that since there was no commission, and the second is that the learned trial court has taken my
Sending a special officer to find out whether there is any access or abuse.
Lordship. Lordship may kindly direct that. There is no difficulty.
On behalf of the opposite party number 1, 2, and 4,
Sir, it is a joint property.
Yes.
Is it a joint property?
It's a joint
It's
property.
a joint property. You are raising a construction. You are a co-sharer.
The allegations that I am raising a construction.
Then what you have done? You are not making any construction. No construction. So we injunct you not to make construction. You are not aggrieved by that. Then who is raising construction?
No, my lord. The case is that
Who is raising construction according to her?
but by the appellate, my lord, before the learned trial court failed to produce any such document that whether any construction is going on. That is why the injunction was refused by the learned court, my lord. That's a written in the order sheet, my lord. Kindly have a glance at
There's been no commission, no.
page 72 of the application, the injunction application.
Yes.
The first line, however, the plaintiff neither filed any document nor got the suit property inspected by any advocate commissioner to show the actual nature and position of the alleged construction.
This can't be done, sir. When the property is admittedly the joint house, there may be a separate dwellings amongst the co-sharer. That does not mean that it lost the character of a joint. And if their allegation is that because of these constructions, their ingress and egress or an access has been impaired, then will it not? Simply, it's a duty of the court to see that send the person and to find out the veracity, whether there is any such thing or not. Then why the court will go on this? Jointness means jointness in all respect. Where the property is.
Lordship, it is in Chagda.
Chagda.
Yes, Lordship. Chagda Nodia. Chagda Nodia.
Far off.
Two and a half hours from here.
Obstructing the crowd.
Not seen. This is actually yes. Paragraph 5. That's it.
Yeah,
So nothing new is going to be. You have already admitted that everything has been constructed.
No, Lordship, there is a fresh construction now.
No,
Yes,
where
Lordship,
is that?
Lordship.
We do not find that you have said so.
Lordship, I will.
Please show us from, we have seen paragraph 5, we have seen paragraph 6.
Yeah.
Nothing has been stated in your petition. Filed before the trial court.
Lordship will kindly come out. Lordship will kindly take up paragraph 7, the last portion, Lordship. Out of family rivalry, they are pretending to construct a house on the suit plot. Be it mentioned that the area of the suit plot being only 5 kathas and already there are separate houses of 4 brothers and 1 house left by father, now dismantled by the defendant number 4. There is no scope to raise 2 houses for the married sisters. It mentioned that legal heirs of late Gobindo Chandra they have
That
gifted.
is a different issue, madam. That will be
Yes.
decided at the time of preliminary decree. What is the stage? Have you filed for partition?
I have filed for
Have
partition.
they filed their written statements?
Yes, Lordship. Written
So
statement has been
otherwise it's ready.
fine. Lordship, also the injunction has
difficult.
been, Lordship will
No.
kindly consider
Very difficult.
that the injunction has been
Sorry.
rejected not only for construction.
File your affidavits. The respondent, you are a contesting respondent. You contested.
1, 2, and 3.
And what about 3?
My inspection is concerned, I am not engaged on.
No, the 3 contested
Number 3
in the trial court.
Yes, 1 to 2, 4. No, 3 was not contesting. Sorry, Lordship. File the written objection.
After hearing the respective parties, we feel that the contesting respondents must disclose their stand before we proceed to decide the application. Stop. Furthermore, considering the nature of the impugned order, we feel that the instant application is required to be heard along with the appeal, as the instant appeal arises from an order by which an application for temporary injunction is rejected by the trial court. We therefore direct the contesting respondent to file affidavit in opposition to the instant application, with the rider that the same would include all the necessary papers filed before the trial court for the purpose of hearing of the application for temporary injunction within how soon? 2 weeks. Reply within a week thereafter. Let the appeal and application be listed after 3 weeks.
I'm deeply obliged.
Wait, is an application for restoration, my lord.
Service.
This means for default, my lord, prior to admission at the order 41.
But service has to be done. Right. Service 2 weeks. Not.
So I'm for the appellant.
Yes.
Lordship, with the respondents before the trial court, Lordship, they are the plaintiff. They filed the suit for partition along with the injunction.
Respondents before the trial court.
Lordship, they
are
the respondents here, Lordship. They have
before
filed
the trial court filed a suit for partition.
along with the injunction, Lordship. The appellant before this honorable court before your Lordship is the son, one of the son. The respondents
Now,
are
what
the
is this
mother and
application? Section 5.
No, Lordship, there is a section 5. There is a delay of 1,465 days delay.
Service.
Lordship, so we have not done a service. Lord.
3 weeks.
Now,
Next.
I'm grateful.
Your lordship appear for the petitioner.
What is this application, madam?
Lordship, this is an application wherein your lordship, it is arising out of a matrimonial suit, your lordship. Herein, your lordship, there was a application filed by the petitioner husband.
Your
Lord, I beg to appear on behalf of the applicant, the appellant, Lord, defendant, Lord, appearing as the defective.
Let us see what is the defect, sir.
Lord, we've cured it. We've put in the requisite, Lord, amount which was.
Let us see.
Yes, Lord. Lord, may I hand up? Oh, let me just.
Let the file reach to us.
My Lord.
You have put in the deficit court fee of 49,900.
Yes, yes, my Lord.
What are the other defects?
Lord, this was the only, Lord, defect.
No, there is a delay of 4,000.
Lord, that we filed a separate CAN application. Lordship will consider that CAN 1 of 2020.
4,509 days. That nearly more than 10 years.
My Lord, my Lord. Lord, I've tried my best to explain it.
Suddenly you woke up from a slumber.
Lord, no, that is not the case. And I've explained it in my, Lord, application. Lord, as to why. Lord, the decree was ex parte. Lord, ex parte decree passed in 2009. Decree sought to be executed in 2021. Lord, decree for damages passed ex parte.
Slander,
Lord, under
or libel.
Lord, under a distributorship agreement. Lord, our specific case before the trial court was barred by limitation, also jurisdiction. None of it was considered. Lord, I will not trouble your Lordship with the merits. First, I need to, Lord, address your Lordship on the section 5. Lord, the only reason is, Lord, this, Lord, the company, which is before your Lordship, the appellant, Lord, the registered office is in Delhi. Lord, we had engaged someone from Calcutta. Lord, the person who was handling the affairs of the company in Calcutta, Lord, he had left the, Lord, the employment of the company in Delhi, and he's gone outside. He's no longer in the roles of the company from 2005.
If I may address your Lordship on that, my Lord.
Lord, and the most important.
Do one thing, you file your opposition.
Yes, my Lord. I seek that direction from your Lordship.
Because it's a very long delay, that opportunity must be given.
I'm grateful.
Lord, also, Lord, one thing Lordship will consider, Lord, execution, he decree in 2009, they come to seek to execute it in 2021.
Is a matter there.
Yes, my Lord, I
Care of
appreciate.
that. We are not going to say or make any observations on that.
Lord, affidavit of service may I file.
Let the affidavit of service filed today be kept on record. It appears that there has been a considerable long delay in filing the instant appeal, spanning over 10 years from the date of the impugned judgment and decree. Full stop. The counsel for the respondent vehemently opposes the said application and seeks for a liberty to file affidavit in opposition.
Grateful.
So in such view of the matter, let affidavit in opposition be filed how soon?
A week. A week.
A week you can file. Next week is virtually a holiday. We are giving you 1 more week. 2 weeks.
Grateful, my Lord. We shall file.
Reply.
Lord, a week thereafter.
Application to be listed after 3 weeks. Come. Satisfied.
Lord, I'm up against it, but Lord, I shall try. Lord, I
It's a
shall.
long delay. I would have understood within 100, 150, no difficulty.
Lord, I will be
You would
relying
not
on.
have invited them.
Lord, I'll be relying on judgments which really say that the quantum of delay is not very relevant as long as my explanation is there.
My everyday's judgment and orders you will find. I am conscious. But if it is an inordinate delay, then they must get an opportunity to deal.
I'm grateful.
I'm grateful to you, Lord. Great.
And this matter I am praying for.
Yes.
In this matter, I am praying for days accommodation, my lord.
What is the defect?
The defect is that, my lord, in the certified copy, according to certified copy, there should be 4 parties, my lord. But in the appeal, my lord, we have implemented only 3 parties, my lord.
Why?
As my lord, this is a miscase arising out of, my lord, application and order 39 rule 3A, my lord. Respondent number 1 has already died before the filing of the application, my lord. It is in the cause title, it is stated that it has died, my lord. Page 11 is the application, my lord.
Yes, he want an accommodation for a day. Yes, next.
Grateful.
Yes. Let's call the next.
I appear to the appellant. But I have instructions to appear on behalf of the respondent.
What is this application? Can 1, 2?
Not can 1 is for stay
and can 2?
And 2 is for my lord, my lord, mistake on my part. It should be an application under order 41 rule 23. Instead thereof I have written my lord order 41 rule 27.
Under order 41 rule 23, what application it is?
My lord,
It is a order of remand.
Order of remand.
So order 41 rule 23 application is filed.
Yes, my lord.
I have never come across in my career both there and here.
My lord,
First time.
this is my lord.
Let
May
me learn.
may I please,
how?
my lord?
Yes, please.
My lord, application under section 25. My lord, the petitioner before your lordship is the mother.
Is a
mother. Mother of a child. My lord, the child is presently aged about my lord, 12 years.
The matrimonial.
Guardians and Wars Act.
Oh, that's relating to child.
Relating to
Yes.
child. Now, my lord, husband filed an